Welcome to this explainer. Today, we're diving deep into the new corporate transparency mandates. Based on a really comprehensive, anonymous expert report, we're going to strip away all that surface-level noise and generic legal jargon so we can look at this strictly through an analytical lens. We're isolating the core ideas, the hidden data collection mechanisms, and the crucial cause and effect relationships that are actively dictating corporate compliance right now. This isn't just a basic review of some new rule. It's an investigation into how the entire landscape of business ownership and personal privacy is fundamentally changing. We're going to completely bypass the filler and get straight to what actually matters for your business strategy. Here is our roadmap for today. We're breaking this down into 3 core sections. First, the core mechanism. Second, analyzing the legal friction. And third, strategic compliance pathways. Let's jump right in. Okay, section 1, the core mechanism, understanding the mandate. So what are we really looking at here? The absolute crucial point is that this mechanism aggressively strips away the corporate veil. It's designed to reveal the actual breathing human beings who control an entity, reporting them straight to a designated financial regulatory authority. For decades, the architectural reality of setting up a limited liability company offered a profound degree of anonymity, right? You could successfully operate an entity, hold assets, and conduct business without your personal, private identity being universally attached to its public-facing operations. Well, this mandate fundamentally shatters that paradigm. It literally demands that the ultimate beneficiaries, the people actually pulling the administrative strings or holding the equity, step completely out of the shadows. They're now required to register their personal identifiable data directly into a massive federal database. For veteran business owners who are accustomed to that traditional separation between personal identity and corporate structure, this isn't just some new form to fill out. It's a massive shock to the system and a total architectural shift in how private businesses interface with the federal government. And looking at how this works in practice, we see this is an entirely separate, mandatory compliance track, focused solely on privacy and ownership. It has absolutely nothing to do with taxation. Actually, let me really emphasize that because it's a highly non-obvious detail that trips up countless business owners. This is not about tracking your gross revenue, and it is certainly not about auditing your end-of-year deductions. The expert analysis makes it explicitly clear that this reporting mechanism is managed by a financial crimes and regulatory authority. It is not your standard tax collection agency. If you just assume this is a routine tax form that your accountant can blindly file alongside your annual returns, you are making a dangerously huge miscalculation. It's an informational dragnet designed specifically to catalog the absolute DNA of corporate structures across the country. And a financial crimes dragnet requires a completely different level of precision, awareness, and operational caution from business owners compared to standard annual tax filings. You really can't treat them the same. Now think about this number for a second. Tens of millions. To put that into perspective, that single number represents the massive scale of pre-existing companies that are mandated to submit these initial reports. We aren't just talking about newly incorporated startups setting up shop this year. No. We're talking about an operational netcast over existing entities, everything from local corner stores to highly complex holding companies that have been operating flawlessly for decades. Let's analyze the cause and effect of this kind of retroactivity. When a regulatory mechanism demands instant compliance from tens of millions of older, wildly diverse entities, it creates an immediate, massive administrative bottleneck. The sheer logistical friction of forcing every single existing business to suddenly audit its own ownership structure and submit pristine personal data to a brand new federal framework that creates staggering operational drag across the entire market. Moving right along to section 2, analyzing the legal friction, the court injunction. Now, as analytical thinkers, we absolutely must aggressively distinguish between established legal facts and rampant market speculation. It's a crucial distinction. The established fact here is that a federal court ruling recently issued an injunction. That injunction successfully halted this data collection, and the interpretation from the bench was crystal clear. They cited this legislation as an unconstitutional overreach of legislative authority. But, and this is a massive but, here is the critical analytical vulnerability. The speculation. The market right now is operating under the implicit, highly dangerous assumption that this reporting mandate is just permanently dead. But as the expert report heavily emphasizes, treating an ongoing, highly volatile legal battle as a final permanent victory is an enormous, unforced error. Assuming a law is completely dead simply because it's currently on pause is a massive strategic blind spot. You hear sentiments exactly like this: a victory for business owners' freedom. This exact framing, treating a temporary injunction as a sweeping victory for freedom, really reflects the implicit assumption driving the current market reaction. It frames the legal friction not just as a highly technical dispute over statutory authority, which it is, but as a fundamental ideological clash over privacy. And honestly, that's exactly why the market reaction has been so incredibly visceral, and why so many business owners are eagerly assuming these reporting requirements have just evaporated completely. However, letting your guard down because of an ideological comfort is a severe strategic vulnerability. Think about it. If this injunction gets overturned on appeal, and you've treated this regulatory pause as a permanent victory, you instantly expose your entities to immense legal and financial liability. You just can't risk it. So our analysis indicates a fascinating, yet really dangerous temporal collision course here. The court appeals process will very likely take longer than the time remaining before the absolute final filing deadline. Just look at the math driving this timeline. The legal injunction is in place right now, sure, but the wheels of the federal judicial system turn incredibly slowly. It often takes upwards of 9 months or more just to resolve appeals of this magnitude. Meanwhile, the statutory deadline for those tens of millions of older pre-existing entities to file is rapidly approaching by the beginning of the next calendar year. Do you see the problem? Business owners are caught directly in a trap. They're getting squeezed between a slow-moving judicial appeal system and a super fast approaching statutory deadline. The collision is mathematically inevitable. That deadline is going to arrive well before the legal system provides permanent final clarity. Which brings us to Section 3, Strategic Compliance Pathways, Actionable Insights. All right, here is the non-obvious dual-track strategic advantage derived directly from the expert analysis. Human instinct usually defaults to binary actions, right? We either aggressively comply with everything right this second, or we just completely ignore everything. But expert-level operational protocol requires the discipline to split your assets into 2 distinct strategies. If your business was formed prior to the current year, you actually have a statutory buffer. The actionable insight here is calculated patience. Hold your cards. Do not file immediately. Utilize that window until the absolute end of your deadline to wait for legal clarity. However, if you are actively forming a new entity right now, you don't get that rolling buffer. The mandate applies instantly at the time of formation despite the ongoing legal friction. Therefore, to protect that new asset, immediate compliance is absolutely required. So let's break down exactly how you execute this operational playbook. Following these exact steps ensures absolute compliance without prematurely surrendering your private data during a period of unconstitutional scrutiny. First up, you must audit. Execute a strict internal audit of every single corporate entity you own to definitively lock in its exact formation date. Get that sorted first. Second, you execute. You quarantine any newly formed entities and execute their ownership filings immediately to satisfy the regulatory authority. Get those out of the way. Third, and this is the most crucial part, you pause. Intentionally pause the filings for your pre-existing entities. Utilize the maximum allowable time the statute gives you to actively monitor the judicial appeals process. By taking this dual-track approach, you are neither aggressively defying the law, nor are you unnecessarily capitulating to a mandate that a federal judge has currently flagged as regulatory overreach. So what's the ultimate actionable insight to take away from this explainer? It's that in a shifting legal landscape like this, calculated patience is a premier compliance strategy. I know it's highly non-obvious to treat inaction as a tactical maneuver, but when a massive reporting mandate is caught in a high-stakes jurisdictional crossfire in federal court, rushing to surrender private ownership data is simply an unforced error. You really have to leverage the law against itself here. Using the rolling statutory deadlines as a shield protects your informational privacy until the highest federal courts make an absolute final determination on the legislative authority of this Transparency Act. As we wrap up this analysis, it leaves us with one massive, lingering question. Will the push for ultimate corporate transparency actually survive constitutional scrutiny? We really have to ask ourselves if this sweeping mandate will ever fully recover its momentum, or if this judicial friction will permanently alter the entire trajectory of corporate reporting. We've comprehensively deconstructed the core mechanism. We've mapped out that incredibly dangerous legal timeline, and we've outlined the highly specific, actionable steps you need to take right now. But the ongoing battle between governmental regulatory oversight and private corporate ownership is incredibly far from over. Keep analyzing the incoming data. Rely strictly on established facts rather than ideological speculation. And always, always leverage the mechanical structure of the law to your strategic advantage. Stay vigilant out there, because the landscape of corporate privacy is literally shifting beneath our feet.